Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 5 and 6 on the speed of 90 words per minute. Start. Alleging cruelty and desertion against the husband, the appellant wife approached the matrimonial court under section 13 of the Hindu Marriage Act, hereinafter referred to as the Act, praying for dissolution of her marriage with the respondent by a decree of divorce. She also prayed for direction to the respondent to return her ornaments given to him at the time of marriage. The family judge allowed the petition and dissolved the marriage of the parties on the ground of desertion by the husband. The appellant was also granted a decree of rupees 12,000 towards the price of the scooter allegedly given at the time of the marriage, and payment of rupees 500 per month as permanent alimony. Both the husband and the wife preferred appeals against the order of the family court, as the wife was not satisfied with the part of the order refusing to grant a decree in her favor in respect of properties claimed by her, and the husband was aggrieved by the order of dissolution of the marriage by a decree of divorce. Both the appeals were disposed of by the impugned order, holding that the appellant wife herself was a defaulting party and neither the allegations of cruelty nor of desertion were proved. The order passed under Section 27 of the Hindu Marriage Act, and for permanent alimony was also set aside. The grievance of the appellant wife is that the High Court was not justified in setting aside the findings of fact arrived at by the family court, and that she had proved the existence of cruelty and desertion against the respondent. It is contended that as the appellant wife was proved to have been living separately, it was to be presumed that the respondent had deserted her. The facts of the case giving rise to the filing of the present appeals are that marriage between the parties was solemnized on 6/5/1987. The appellant wife lived with the respondent husband till 21st June 1987, and according to her, the marriage between the parties was never consummated. After 21st June 1987, the parties started living separately. The appellant alleged that her parents spent more than rupees 80,000 with respect to the ceremonies of the marriage and also gave several articles in the form of ornaments and cash as per demand of the respondent. The respondent and his family members allegedly made further demands of color TV, refrigerator, and some other ornaments besides hard cash of rupees 10,000. The father of the appellant obliged the respondent by giving him rupees 10,000 in the first week of June 1987, but could not fulfill the other demands of his parents. The respondent and his family members were alleged to have started torturing the appellants on false pretexts. Aggrieved by the attitude of the respondent and his family members, the appellant states act seeking dissolution of marriage by a decree of divorce along with prayer for the return of the property and grant of permanent alimony. The trial court held that the statements of P.W.2 Jagdev and P.W.3 Hardev were relevant and not merely hearsay evidence, and their statements would not be unreliable merely because they were relatives. The delay in filing the FIR was held to be explained as the complainant was proven to be unfit to make the statement on the day of incident. The court further noted that though the accused claimed to have been injured, they had not filed a complaint or put any suggestion regarding the same to the prosecution witness. The injuries on the accused were simple in nature. The court held that the conduct of the accused in traveling 1 kilometer from their house armed with a gandasa and inflicting injuries on the complainant proved their common intention, and the medical evidence proved that the injuries inflicted were simple and, in one instance, grievous in nature. The trial court convicted the respondent and sentenced him to rigorous imprisonment for 3 years with fine of rupees 1,000 for offence punishable under section 326 IPC, and rigorous imprisonment for 1 year with fine of rupees 500 for offence punishable under section 323 IPC, and Love Kaur was also convicted under sections 326 and 323 IPC, read with section 34 IPC, and awarded the same sentence. Aggrieved by the judgment of the trial court, the respondent and his wife preferred appeal to the Sessions Court, which noted that there was documentary evidence proving that the accused and complainant were treated by the same doctor. The presence of the accused at the crime spot was held to be proven. Love Kaur had no injuries on her person, and 6 injuries on the respondent were held to be simple, and its non-explanation was held to be not fatal to the prosecution case. The Sessions judge held that though PW2 and PW3 reached the spot afterwards, the statement of the complainant was enough to conclude that it was the accused who inflicted the injuries. The Sessions judge, however, held that the finger injury was erroneously held to have been grievous, as the radiologist who conducted the X-ray of the said injury and whose report was relied upon by PW6 to hold the injury as grievous was not examined. The Sessions Court set aside the conviction of the accused under Section 326 IPC but upheld their conviction under Section 323 IPC, upholding other findings of the trial court. The Sessions judge also noted that Love Kaur was an old lady who herself had not caused any injury to the complainant and was a first time offender, and released her on probation on a bond of rupees 20,000 after setting aside her sentence of imprisonment with fine. The respondent was, however, sentenced to imprisonment of 1.5 years with fine of rupees 1,000. Aggrieved by the judgment of the Sessions Court, the respondent preferred revision before the High Court. The respondent did not challenge the order of conviction but sought reduction of the sentence awarded to the period of imprisonment.